Sharon, are we ready to go? Okay. This is the regularly scheduled meeting of the Ethics Commission of the town of Chesapeake Beach. All commission members are present. Also present is the commission's counsel, as well as the commission's clerk. So we have a quorum and are ready to proceed. And as usual, we will start with a Pledge of Allegiance. Visible. The God. First agenda item is the approval of the agenda. Agenda has previously been distributed. I have only one comment myself. We should really have to add an additional agenda item, and that is to deal with the complaint of Mr. Duval. He was the gentleman who spoke at the end of our previous meeting, which is properly reflected in the minutes. But meanwhile, we haven't been idle. We dealt with that complaint, and I think we should say a few words about that, so that the minutes can show that complaint was attended to and disposed of. Okay. The next item is the approval of the minutes of the previous meeting, that is the meeting of August 6th. And the minutes were distributed. And again, I have one comment before anybody else. The final item shown in the minutes is item 14. It deals with an undertaking by our esteemed council to put into proper form certain amendments that we want to make to the ordinance, and that request was made prematurely. We have identified a number of changes we want to make. We have discussed other changes, and I think there's a general consensus that the wording of the ordinance would benefit from improvements. And rather than making amendments or proposing amendments to the town council in steps or small increments, I think we should deal with the overall picture first. As for no other reason than I don't think we want to go to the town council again and again and again. I'm afraid what we will hear is, can't you guys make up your minds? Come to us once and not again and again. The same remarks could also come from the State Ethics Commission, which has to improve any amendments to the ordinance. And I think it wouldn't be a wrong thing to leave the language in the minutes as it is. It remains true that we will ask council to put the amendments in the required form, except we will do this not first thing tomorrow morning, but when we're actually good and ready. And if you would like that last paragraph of the minutes struck out because it's premature, we would do that, and I would propose to approve the minutes with that correction, or else we leave it as is, because it remains true that we asked and council agreed that to do that. And
It is actually item number 11, I believe,
Yeah,
not 14.
that's what I thought too.
11.
Item 11 of the minutes of the last meeting
it's the
was the one that we discussed in terms of,
oh, here we are.
and we added, I made a comment and Sharon kindly added
No, it's the so the last page. It's item 14, comments by commissioners and members of the public. And no, sorry,
item 11.
It's I got the wrong. That is Mr. Duval.
Go back to 11.
Oh, it's part of the item 11 discussion, and it reads: Commission Council will prepare a draft that will incorporate the following items. One, I think there was a third. So that remains true, except we are not going forward right away, but wait till we have the whole wagon load. All right. So with that understanding, we will
Approve the minutes, yes.
approve the minutes. All right. Now to the more interesting part. Well, actually, not so interesting. We are required by state law to submit a report to the State Ethics Commission once a year, and which essentially says that we have the ordinance in place and we are in compliance with it, and that was done. The deadline for the is not until August 1st, but we, as soon as September the 31st passed by, we've found that. For good order, we need one confirmation from the clerk. I signed the declaration, which is in a prescribed form, and it calls for the ordinance in its present form to be attached. And I take it that Sharon, you did that.
I did.
Yeah. Okay. So no, we are in compliance. Next item, it's 4C, letter C. It's a leftover from the last meeting. We discussed some laggards and delinquents among the persons who have to file the annual disclosure statements. And we had everything was in place. We had, one statement which had not been filed yet, and one or two minor technical errors. These errors were taken care of, and I met with Sharon. We went over that, and we also had prepared a punishment to the person who had not submitted the form for the past year. We never went forward because on the last possible day, lo and behold, we got the disclosure statement, and it had to be done because the delinquent filer is now running for town council, and so it was like the 100-meter dash at the recent Olympics with was it hundreds or thousands of a second to spare. I'm telling nobody's secrets. The filer is currently a member of the appeals board, and as disclosed in this disclosure statement, he is a policeman at the Washington, the DC Metropolitan Police, and that might explain why he didn't feel it necessary to hand in his disclosure statement when he was supposed to. That leaves one question. He was late, and this commission is entitled to levy a late filing penalty. So technically, we should still go after him and say, you owe us. So by now it would be five months, $2 a day. So it's a little more than trivial, particular since he needs all his money to put up election signs and mailings. But is there any sense that we should go forward and levy a penalty, or just let it ride?
I suggest we drop it.
Drop it.
Yeah. If it gets repeated again,
it's my
then
it's my sense.
It becomes habit. Yeah.
So it would be the very first time, to my knowledge, that the Ethics Commission has ever levied a penalty. And yeah, he did. We had one person who quit, moved out of town, and we never did get this statement. And of course, we didn't spend any money to chase after her. And in any event, I don't have a very precise notion how much it would cost to obtain a court order saying, you must pay. It'll probably at least as much as the amount of the penalty itself.
I have two.
I just wanted to. I'm sorry.
Yeah, I have two comments. One is that I agree that we should drop it, and if the person repeats that, then we would impose the fine. But furthermore, tying it to the earlier conversation we had when we reviewed the ordinance, I think it is in order to review the penalty to see if the amount is even significant or not, and maybe raise that in the next revision.
Yeah, I agree. It's got to be worth our while as well to go after
Right.
someone.
You know, for $300, frankly, the administrative cost associated with that far exceeds that, and it's not that meaningful to most people
Well,
anyway.
there's nothing this commission can do about him his running for the position on the council.
No, right,
You know,
right,
there's,
sure, absolutely, right.
and maybe somebody, well, his senior should talk to him.
Yeah.
Well, okay, is the agreement that you don't want to see the remedies of the
Right. Yes.
so the minutes can show that you know, all delinquencies were properly remedied, and we have nothing left over. Next agenda item, letter D, review of the 2023 and 2024 public disclosure statements of candidates for elected office. You'll recall that earlier we had designed a report form for the portion of the current year for which candidates for office must file a disclosure statement. They were all received, and yeah, I believe everybody has seen, you know, the statements that have been distributed. So there we are all clear, all clear there, and yeah, that's done. Next agenda item, letter E, as a response to complaints by the town attorney, Mr. Towns. There were two separate complaints, one directed against a prior town lawyer, and the other one against a prior town engineer. You know, both persons have delivered you know, their responses to that complaint. The one from Paul Woodburn, the former engineer, came very late, and I think I saw it this past Saturday, but I sent it to everybody, and theoretically you may have seen it, if not read.
Right.
And you know, we also found a where is it? Now, both respondents basically say, the lawyer says it in many lawyerly words. The engineer has a spokesman say it in fewer words. But it seemed to me, if I may, utter my opinion here. It is true that Mr. Blitz at one time was the town lawyer, and his friend was the town engineer. And now I'm saying this from memory. Again, from memory, both of them left their positions after the town election of 16 years ago, 16. So that would have been in the early teens. In any event, it certainly was before the first version of our ethics ordinance was enacted. That was in 2016. And at that time, neither Mr. Blitz nor Mr. Woodburn were in their previous positions. So I don't think we need to determine what these positions were. It's pretty clear neither of them was an employee of the town. They were colloquially referred by everybody as the town lawyer and the town engineer, respectively. But I was sort of dreading the chore that we would have to go through historical records and say in what capacity were they. We're pretty sure they were not employees. But Mr. Blitz in particular said, no, I was never anything other than a lawyer hired from case to case to advise the town. And I think it's the, if I understand, Mr. Woodburn's submission, I think he is saying pretty much the same thing. I'm a professional engineer. I was never, yes, I did work for the town, like other engineers, like other lawyers, and but that didn't put me in the position of being a town official. Now, if my analysis is right, we don't have to make that determination. We can simply say the present ethics ordinance is not and cannot be retroactive.
Right.
I'm not sure we even need to go that far for this reason. Under the rules of the commission, complaints have to be filed within 180 days of notice. I pulled the minutes of the Board of Appeals hearing that seems to be the subject of the complaints. It's dated September 19th, 2023. Mr. Pounds is on record as counsel for the town. It makes reference to Mr. Blitz and Mr. Woodburn, who was called for testimony. As of that date, they were on notice that there was a potential conflict of interest, and any complaint relating to that under the rules of the commission should have been filed within 6 months of that date.
It wasn't.
It was filed, I'm sorry, Mr. Pound's complaint was filed on July 30th, 2024.
Well, let me quarrel with you. It is true that the this commission has rules of procedure, and they say, among other things, they deal with complaints, and they say, as you say correctly, that any complaint must be filed within 180 days after the complainant knew or with proper diligence, should have known that there was a conflict. And but I am not sure. I confess some sloppiness in my taking this office. I didn't realize that we had rules of procedure that had in fact been enacted. Among the documents I inherited, there was a draft of rules of procedure, but it said on its face that it had not been acted on by the commission. But meanwhile, subsequently, I discovered, thanks to Sharon, that there is in fact an executed version, which recites that it was adopted by this commission, unbeknownst to your only semi-competent chairman. And but do we should we rely on that preclusionary, because it's yes, it's written down, it was voted on. This commission does have, by state law, the ability to design rules of procedure and certain other regulations, but these are nowhere accessible to a member of the public unless somebody hears about it somehow and goes to the town. That would be the town clerk, who would be the official keeper of the town records. And so somebody must know already that there are these rules with the exclusion or preclusion of rule of limitation, however we want to call it. But is that effective as against a citizen without knowledge, without notice, and without a reasonable ability to inform himself?
Does anyone know offhand? I thought they were online. If you go to the
I think there are two different issues we're talking about. One is the accessibility of the ordinance versus what is in the ordinance. Is the 180 days in the ordinance or not? Is not. So it's not in the official ordinance. So Mr. Pounds, and the accessibility issue, I'm not, we should address that at some point, but in the case of Mr. Pounds, he's the town lawyer, and of course he has access to whatever document he needed to. But from what I gather, the issue is that the complaint is not applicable because neither one of these individuals were in any capacity employed by the town. Now, the response I saw, I think, from Mr. Pounds was that, well, we have to go through and sort this out under oath and all that. But that's not something that I think our commission needs to do. I think the complaint is inadequate, at least at this point, based on the responses we have received, because it doesn't apply to the individuals.
I would agree with the reasoning, and I think we don't need to fall back on the 180-day rule. I'll make that my chore to find out whether the rules of procedure are in fact publicly accessible. And, I never found it. But then, I claim no particular skill or let alone expertise in, internet searches. There's you can search the town charter, you can search the town code, which includes, among other things, our ordinance. That is all there. But my searches did not produce the rules of procedure, which is why I was happily sitting there. Oh, okay, one less piece of paper to study, and said, I'm not going to do anything about this. What I thought, or what was a draft, not knowing that in fact had been voted on and become a commission regulation. And I'll talk to the town administrator, and say, that has to be somewhere searchable. And if you go to the town website and you click on government, that takes you to the town code, and it should also take the searcher to the rules of procedure. It must be possible to make that findable. Surely, I wouldn't know how to do it, but there are plenty of people who can do it in their sleep. But council, I don't want to sort of push you into taking a position that you're not comfortable with. But do you want to give it some more thought and confirm to us, if you can, that in order to answer the Mr. Pounce's complaints, all we have to rely on, all we need to rely on, is the fact that the prohibition about the violation of which he complains didn't exist at the time when these two people had positions with the town. So even if they had been employees or statutory office holders of some kind, it wouldn't matter. Yeah. And Mr. Blitz has a lengthy disquisition about the retroactivity or the lack thereof of the. But it seems to me now that I am saying all this should be crystal clear.
One question that was raised is that it was, Woodburn, was he in fact the town engineer? He seems to suggest he was not. Mr. Pounds has alleged that he was. Seems to me that should be a fairly easy thing to check.
It seems to me that also may be worth a discussion with the town administrator. It probably was not perfectly clear what exactly the position was that both people had. There was a label. Oh yeah, that's Mr. Blitz. That's our town lawyer.
Yeah.
That was the label that was. But reading how Mr. Blitz describes his activities, and without looking for further evidence that all that is in fact true, we an iron fact is, at that time, the town did not have that paragraph that we are wrestling with, which says that a former town official may not take up weapons against the town. So if okay, can we leave it that way, and we will leave it to council to think it over, and if you find any flaw in our present reasoning, let us know, and we'll go back to the drawing board.
Get your memo.
And, so in the meantime, I never heard back from Mr. Pounds, by the way. To my very first letter is, we have the 180-day exclusion rule. He didn't respond to that. And, but then, both of them came back with fuller factual statements, and so we looked at those. So I think we can leave item E, response of the complaints by Attorney Pounds, with us, the understanding that if council concludes that no, we are mistaken, we'll revisit. And we have another item that should be part of the agenda, and that is the disposal of the complaint of Mr. Duval, which is referred to in the minutes. And we looked at it. We consulted with legal counsel. What he has to say is, very interesting, but it does not identify a specific breach of the limited and very narrowly defined catalog of evil deeds that we can sanction. And the very first version of the ethics ordinance, of which I could only find a draft, but it became law at one point, and the state just smashed it down. What was I saying? Yeah, it did not contain a provision equivalent to the prohibition of against former officials and taking up arms against the town. I'll make sure to look at the actual version of that ordinance, but I'm pretty sure that what I've seen is the version that was eventually enacted. And but getting back to Mr. Duval, we wrote him a letter that I believe everybody has seen, which basically did the same thing that we did in at least two other cases. This is, what you're describing there smells bad, but it doesn't, hit the targets that a viable complaint must hit. And that infamous 2016 version did have a provision that says if the Ethics Commission learns about someone's conduct that would be considered unethical by widely accepted standards, then the commission can take appropriate action. But that never became law. That became law for 1 year, and it's not the law now.
So that was
But
actually,
it may be if we can collectively muster up the gumption to propose such a clause to the council, would be the new council after the election. I mean, nothing will happen between now and November 5th, I think it is. It seems to be something that the public expects. If the public is properly represented by people like Mr. Duval, by at least one of the candidates for mayor would complain, and other people. So I will leave that. Of course, we will look at other things where we think that the ordinance could be improved. And that gets me to the item. Well, maybe we should go to item G before we go to F. F is scheduling the next meeting, but G is comments by commissioners, and we have no member of the public, which in a way is well, it's. I was going to say it's good, with a little bit of tongue in cheek, because that means we don't have to do anything. But I think it is better if people come here and complain. That indicates there is something foul in the state of Denmark, and at least we can. I think we have seen enough to justify taking it to the council and say, look, this is what we propose, and it's up to you to go forward to say, oh no, this is too open-ended, and we can't trust 3 appointed guys, and who knows what kind of deep end you might go off on and so on. All this will be said, but that doesn't mean that we have to anticipate and make a retreat prophylactically. So I will do my little talk with Administrator. Interesting what will happen after the election. So it's unusually competitive this time. If I were Pat Irish Mahoney, I would tell you all whom you should vote for, but I won't do that. Not
That would be a violation
not in
of
this room.
ethics, right? The public setting.
privately outside. I'll be happy to tell you. No. All right. And any further? Anything further? Anyone? All right.
One thing we had discussed in the past, possibility of changing the name. Has there been any further thought about of this commission?
Yeah.
I think the change, the issue I raised is really the discrepancy and misalignment between the name and the charter of the commission. And with the number of items that we have, especially the sentence that you said it was removed from the ordinance, which is the commission would review any seemingly unethical actions. Now that would broaden the charter for this commission, and therefore it would be more consistent with the name. Because the way it is right now, there is a perception that this commission is ethics commission and all ethical issues should be brought here. And of course, we have seen it time again that our response is that, well, it's outside the thing. So my suggestion to either change the name to make it clear that it's very narrow scope, like the disclosure commission, or if we can expand the ordinance to be aligned with all ethical issues, then we would be fine. So I think it's an item that we need to discuss as part of
I
the
think-
overall.
I think we need to discuss it, but I also think that opens up a whole can of worms for us.
It will, and I think and for the predecessor.
Exactly.
Yeah, exactly.
And do we
But
want to take all that on? See, that's
at the
that's
same
another-
time,
yeah.
it's what happens to unethical issues in the town of Chesapeake
Sure,
is
sure.
the question.
Yeah, that's a question.
Okay. Can we adjourn?
Did we set the
New date.
date
Oh,
for
date. Yes. Can we set a date?
Sure. What is your view? How long from now
well,
do we need to meet?
I no longer go to the office. And yeah, I have dates now and then, mostly is to visit my friends and helpers wearing white lab coats. And I don't know what my next big day is. I have a small date next week, and that will that'll be the clearance by the cardiology people. And the clearance means that they will say, we think it's okay to put this man, proper narcosis, a seizure. And once I have that, one of the nurses referred to it, we need this piece of paper. And gives you an indication about the bureaucratic nature of modern, this healthcare. And I have right now I have no clue when they will actually give me a date for to replace that knee. The procedure itself will be basically in and out. my guess is they will probably keep me overnight. They like to do that because I'm old geezer, and I hope that will be a matter, not hoping for days, but a few weeks rather than months. You'll understand that.
Absolutely.
As far as the commission business is concerned, when do we need to meet? Is there a business that we need to take care of? I mean,
No, but we should start making nails with heads, as they say in Germany, and which means sitting down. And I'll be happy to do my version of that. Go through the ordinance and say what should we change.
Right.
And there are a lot of them. I think Rod, you mentioned it. What's the difference between a board and a commission? Is there a difference? Or is it, are we thinking like the English? A title that was created in the 1700s or earlier, we just keep it. But that's kind of charming. But that's not how a modern republic should choose its nomenclature for offices and so on. I think this debacle with the Mr. Pounce's complaint is we have to make sure that the job titles that the council hands out to people, actually matches job titles that we have in the ordinance, and so that and that would also mean that revisiting something that we discussed, the famous sentence that if a position is filled by a firm, then the firm itself must make the disclosures. And if a firm tries to do that, he says, does a close relative of you have earned income? Now, a firm cannot have relatives, close or otherwise. So we have this dictate. On the other hand, quite clearly the questions themselves are aimed at an individual. They don't make sense in any other context, and that in turn would impact the engagement practices of the town. I've seen one sample of an engagement of a professional, not yours, and not that of your predecessor either. But the town will contract with a firm acting through its regularly established, administrative bodies or persons. And the contract will then specify that the person who will be the laboring or attend all the council meetings and so on, that will be an identified individual, and the contract will also provide that there is an understudy, so that for some reason, the designated town lawyer is not available. then somebody else will step in, somebody who has already been designated. And but then the town will also have to say to management of the firm, by the way, the designated person, or maybe both the designee and the under designee, they become subject to our disclosure requirements. So we have a, it's not that the firm will have to make disclosures. Much of it is would have to be, totally rephrased, and much of it is really of no particular relevance for the day-to-day operations of the town.
So Peter, back to the date for the next meeting. Do you think sometime in November would be adequate for us to have your first cut or Lee's cut by then, or is that too early?
Yeah, the short answer is yes. I'm the one who is supposed to move this thing forward. Yeah, I will.
And that will be a work session, correct? That will be a work session?
I'm sorry?
That will be a work session?
It'll be a work session. Yeah.
So, November, of course, we got the Thanksgiving and everything towards the end. Should we shoot for mid-November?
Yeah.
Earlier the better. The earlier the better. So I'm just going to throw November 5th.
If there's
5th is election, sorry. Yeah, no.
there's election day, I think we should have it
Before
after
or
the
after
election.
4th or 6th? Any preference? I'm clear all that week.
I'm in trial that week.
You're in trial. Okay, so should we go next? Is that better for you or
How about
worse?
the 18th, Monday, the 18th?
18th.
November.
As far as I can see,
That's fine, yeah. They take the
I'm not doing anything. Okay, November.
So let's agree on 18th for time being. I don't see it on my calendar, the thing.
And what was the date again? The day?
November 18th. That's the Monday.
18. Okay, what weekday is it? Is it a
Monday.
Monday. Traditional.
One other issue, I believe it might be approve the recent public disclosure statements we got with the changes that you suggested.
Yes, it would have to mesh with the revised ordinance, but it'll take months. If we agree on something, we won't get that done on November 18. It'll be done sometime with any luck in January.
I'm just talking about the ones that were recently filed.
Well,
Fairly.
if I can find a volunteer who would be willing to do that. What I would really like to see is that we people don't seem to read carefully, and so we have to take that into consideration and structure it so they're properly entertained and actually read with interest, or simplify the instructions and maybe say things more than once. Do a little bit, in the version that we have.
I think what you're asking for is
Words,
approval of these.
Okay, so you
for-
do
at
this, you do
meeting.
this, you do that, so that your entire disclosure statement will consist of
Mhm.
this piece of paper, this piece, that piece of paper. I think we'll have to, bring it down to that level.
Back to item D.
Oh, we skipped that.
Can we approve these?
My fault, but they are okay.
Okay.
I mean, you have to share the blame. Sharon sent it out to
Right.
everybody,
Yeah.
and we went through that, and most of those guys, everybody who is already an incumbent of no matter what office, they only had a 2-page piece
Right.
of paper, and that worked out very well. And I think we have to come up with something similar, because even the online fillable version, there is still too much stuff in there that is really not necessary. But it's the best we could do for the previous season.
Can I make a motion that we approve them for this upcoming election?
Peter, I think what they're talking about is the email that you sent with a few things
Wait, I
that,
can't hear you very well.
I think that they are referring to the email that you sent out of things that you noticed that there were a few.
Which email? Do I send out emails?
About the disclosures by the candidates, you
Oh.
reviewed them and you made some comments, and both of us agreed with your observations.
Yes.
The question is that, are those fixed and are we approving those for the election, right? Is that?
They're
Oh,
not
all right.
fixed.
So
They're
you're
not
saying
fixed.
we should take a formal vote that the disclosures for the existing incumbents, that is the 2024 disclosures, are accepted.
Or not?
With the corrections noted.
With the corrections noted, correct.
With the corrections noted. There are a few corrections that you identified
Yes.
that need to be corrected, and Sharon is saying those are not
Do you
fixed
have
yet.
his email? Is that what you were looking at?
I don't have it in front of me, but that is what I was referring to, those forms. And
She's got
So
it.
the candidates need to make those corrections, basically, right?
Oh, yeah. So I thought this would be done the same way you dealt with the
know,
other
but they-
situations,
They want
and you would, since this is a sworn statement, even if something is like one person dated his or her statement 2022. Now it's obviously it refers to
They need to
24,
be correct.
but you have to call that person or text or whatever and have the person say, "Oh, my mistake. I meant 2024," and then you cross it out and do the hand. I'll be happy to pay you another visit and.
I can follow up on these, but they were saying is that
Well,
action,
yeah,
motion, something to the,
we'll take formal action.
we'll follow up with
In the minutes.
things that you identified.
The minutes would be pretty much the same wording we used. Errors and omissions were identified. Will be fixed. Has to be fixed. I think it's this, the I think it's if it's written down somewhere, the election schedule. Uh,
17th, I think.
17th, the election board will officially certify all the candidates. And the 24th is the last date for a candidate challenge. And one of the reasons why it can be challenged if the disclosure statement wasn't correct or complete.
So we agreed that there should be in the minutes that the clerk will follow up and address those
And
discrepancies.
the minutes could show that the clerk and the corrections were identified, and the actual correction, physical correction, be done by the clerk and verified by the chair.
That works.
Becoming the best of buddies there. All right, then we are adjourned.
Adjourned, yes.
Everyone.
See you too, yes, yes.
That was good.
Now,